privilege to have you all here. So thank you. It's lovely to see so many people from Deakin University and the law school itself, and some students. Very, very nice. Thank you for being here. Now, on the screen, we have Aunty Di, and Aunty Di is a Wurundjeri elder who identifies with the Garrawillumballuk clan. She's contributed to Australian society through her work with the Aboriginal and Torres Strait Islander community and government in a range of fields, including health, childcare, education, native title, stolen generation support and other community work. Aunty Di's contributions have been acknowledged by the awarding of a Medal of the Order of Australia in the 2019 Australia Day's Honours List, and she was also acknowledged by the Victorian State Government when she was inducted in the 2017 Victorian Aboriginal Honour Roll. Aunty Di was going to come and do a personal on-site welcome to country, but for various reasons she's been unable to do so. So she's very delightedly, thank you Aunty Di, agreed to do the welcome to country on Zoom. As well as having Aunty Di on Zoom, just while I've got people in the room listening, there are a number of our attendees are also on Zoom, and the session is being recorded. If you have a deeper version to perhaps being peripherally photographed, you might want to take a seat in the back row somewhere. But other than that, we intend to use this session for our students at some point of time. So Aunty Di, can I hand over to you, please?
Yeah, thank you. I honour my ancestors and my elders, and I pay homage to the sacred grounds that we're on. I wish to acknowledge any elders of different nations, any Aboriginal and Torres Strait Islander peoples, any First Nations peoples from across the waters, and I acknowledge you all, and I pay my respects to your ancestors, elders and families. It's an honour and a privilege to be able to do your welcome today, and I think, the topic from Mabo to the Uluru Statement of Heart is something that's passionate in my heart, and particularly with the Aboriginal community. And it's important that, while we move forward, we remember what happens in the past, and we remember the staunch leaders that we've had over the years and what they've stood for. But I'd like to ask each and every one of you to talk to someone that you don't know and share who you are and where you come from. I firmly believe if we can understand each other and our cultures, that we can live in harmony. When we live in harmony, we eradicate racism and stigma, and we pave the way for our young ones. They can live in peace and walk our streets without fear of any harm. And all it takes is an open heart and an open hand. So I offer you all my hand in friendship so that we can journey together. May Bunjil, my Creator, surround you all and give you strength and resilience. Womanjika, Wurundjeri Balak, Yuman Gundibik, that means welcome to Wurundjeri country. For those of you that aren't on Wurundjeri country, I can't welcome you, but I can acknowledge the country that you're on. And I say Nungojin, that means thank you. Thank you for allowing me to be a part of your journey this evening and have a wonderful event. Nungojin.
Thank you, Aunty Di. I think she's gone. Thank you, Aunty Di. I'd like to start, so thank you for the welcome to country. I'd like to start this evening with a special acknowledgement before we actually get into the details of the panel. For those of you who don't know me, I'm Professor Jenny Lyde-Ellis and I'm the Dean of the Deakin Law School. The special acknowledgement is to the gentleman on my right, Dr. Brian Kean-Cohen, one of our panellists, who was junior counsel in the Mabo case, acting for 5 plaintiffs in the case, including Eddie Mabo himself, and has added to the statement of the claim at the very last moment the Meriam people of the Murray Islands. Brian has donated his partial copy collection of Mabo papers to Deakin Law School. The significance of those papers is recognised by the collection, along with Eddie Mabo's personal papers, being included on the UNESCO International Memory of the World Register. We're very privileged at the law school to have custodianship of the collection, which is, of course, available for research purposes. If you're a student and you would like to work with Brian to access and bed down our the additional materials that he's making available, such as maps, photos, etc. Please, or if you know somebody who might be interested in doing that, please come and talk to me. There's a research position available. So for our panel, thank you, Brian. I mean, we are very privileged to have you donate your collection. Law school, yes, please. It's 30 years since the Mabo decision on the validity of native title was brought down in the High Court in 1992. Coincidentally, it's also 30 years since the Deakin Law School was established, so it seems like a happy coincidence for recognition and celebration this evening. 30 years is an interesting passage of time, time enough for Deakin Law graduates, starting in 1992, to become significant influencers and decision makers in their chosen fields, time enough for us to celebrate what the Mabo decision achieved and to acknowledge all that remains to be achieved in the recognition of Australia's First Nations people. Dr. Shireen Morris, who's sitting on the far end, makes the case for a constitutionally guaranteed Indigenous body in her book, A First Nations Voice in the Australian Constitution. As a constitutional lawyer, she argues that a constitutionally enshrined voice is deeply in keeping with history, philosophy and design of the Australian Constitution. Acknowledging the challenges posed by a referendum in this country, where those of you who are familiar with the constitutional law will know that only 8 out of 40 referenda have passed. That's 5.5%, not a very good success rate even when you're applying for a grant. She contends that a constitutionally guaranteed voice is the only proposal that can secure a voice for Australia's First Nations people. And many of you in the room will know Professor Mark Rose, a Gunditjmara man. Mark was born before 1967, and so that is, he was born before the referendum that gave him and Aboriginal and Torres Strait Islanders the right to be recognised as Australian citizens in their own land. He is directly impacted by Australia's policies on Aboriginals. His father was taken away from his family when he was only 6 years old, and his father never saw his mother again. He shares the story of many Aboriginal families who are directly affected by government policy which removed Aboriginal children from their families and brought them up in foster care to be more white and perhaps more like servants. Mark has taken those experiences and turned them into a passion for teaching Aboriginal knowledge and history in the national curriculum. Welcome, Mark. So, Brian, so the format is we're going to just have a little sort of brief introduction from each of our panellists, and then please be thinking of the questions that you might like to ask, because it would be nice to have this as an interactive session. But of course I have my own questions to start with. Brian, you commented in your book that it was an uphill battle getting traction with the case. You noted that those in power in Queensland probably saw the case and the statement of claim, and I'm quoting, as a communist-inspired subversion driven by a bunch of pinko loony lawyers from Melbourne, and that there was one world north of the Tweed and the civilised world was below. It took 10 years and what seems to be an incredibly tortuous route from a legal viewpoint, but the outcome of Mabo is that it overturned the colonial myth that Australia was terra nullius, an empty land belonging to no one. The years since 1992, I think, seem to narrow the decision through the passing of the Native Title Act and various amendments. And I know this concern about legislative responses feeds into Shireen's discussion on why the Uluru Statement from the Heart needs constitutional reform. But Brian, you were there. Can you give us a sense of what it was like working on the Mabo case for 10 years and tell us about the plaintiffs, the trial and delivering the outcomes to the Miriam people?
Well, thank you, Jenny, and may I also mention my respect for the elders past, present and emerging. Working for 10 years on the Mabo case was a very up and down experience. The case would go nowhere for a year or two. For example, in the first year or so, we were concerned with drafting the statement of claim, which was filed in May of 1982. It then took Queensland about a year to provide their defence. It then ultimately began the trial in 1986 before Justice Moynihan in the Queensland Supreme Court. The Queensland Parliament passed a law called a law which in one page declared that any traditional rights to the Torres Straits that may have existed since colonisation in 1879 were hereby annulled without compensation. So that meant we had to adjourn the part heard hearing of the trial to take that issue to the High Court on a demurrer pleading. That High Court hearing was heard in 1987, and the decision came down at Christmas time in 1988, 4-3, that the claim could proceed because the proposed Queensland law was contrary to sections 10.1 of the Racial Discrimination Act. So it was a very close-run thing in Mabo number 1. Had that case failed, had that challenge in the High Court failed, end of Mabo, end of the case, because the Queensland law would have applied. Following that, so you can see that whilst awaiting that decision, we've piled all our papers in a corner, many of which you now have, Jenny, and attended to our such other practices as I had. And of course, our leader was Ron Caston, who was a wonderful silk at the Victorian Bar, who did an enormous amount of human rights work in various jurisdictions, especially in the High Court. The High Court had a high regard for his abilities, and he very tragically died after surgery in October 1999. Working with him was a delight. Working with the plaintiffs was a delight, especially the 5 plaintiffs and the Murray Island community leaders who supported the case by way of being witnesses. You should realise, however, that there were some very torturous moments. For example, the final determination of facts by the trial judge was that all of Eddie Mabo's claims were rejected. The claims on Murray Island were to individual garden plots or areas on the offshore reefs or particular areas further offshore. We had 5 plaintiffs. Saluya Mapo died in 1985, so we had remaining 4 plaintiffs. By reason of pressure applied by the Queensland Department of Aboriginal and Island Affairs officers, and I am talking on the basis of information provided by David Passy, one of the leading plaintiffs, those officers pressured our plaintiffs, which you cannot do, and 2 of them, to our astonishment, the week before the trial was about to start, 2 of them instructed solicitors in Cairns and they withdrew. And we were astonished. We were very much had to quickly reorganise. And one of those plaintiffs, very fortunately, Reverend David Passy, an Anglican minister, returned to the case after various anthropologists spoke to him later on. And in the upshot, Eddie Mabo failed, Reverend David Passy and a school teacher, James Rice, succeeded in about 2 or 3 blocks out of 40 blocks. The attrition rate was terrible. Queensland threw everything they could at this case. Interestingly, Junior Counsel for Queensland was a very nice lady called Margaret White, who was supported by senior counsel, numerous bureaucrats, instructing solicitor. She ultimately went to the Supreme Court of Queensland and conducted the Dondale Boys Home in Royal Commission, you might recall. So we were facing formidable opponents and enormous resources against us, and we had to rely on legal aid from the Commonwealth, being particular grants from the then Attorney General and Minister for Justice. In the end, we put no submissions on behalf of Eddie Mabo to the High Court, to the full High Court, in the final hearings in 1988, in May of 1991, because all of his claims were rejected. So he had no basis of fact to put submissions on his behalf. All the submissions focused on the two moderately successful plaintiffs at trial, i.e. Reverend Dave Passy. I called his evidence in his clerical robes, an Anglican minister in the Archdiocese of Carpentaria, across the Torres Straits. He spoke about how Christianity, which arrived in 1871 through the London Missionary Society, worked with traditional rights and interests and traditional life and did not extinguish that life. And of course, Queensland submissions were exactly the opposite, that everything had been destroyed. Mr. Kiancoan is talking nonsense. There is no possible suggestion that there's an observable, recognisable system of custom and tradition founding traditional rights in areas of land or seas. And Your Honour, you should throw out this case. Well, there were positive findings for two plaintiffs, Dave Passy and James Rice. And that was the basis of submissions to the High Court. The case was full of surprises, however. On the last day of the 3-day final argument, after 9 years of litigation, the Chief Justice, Sir Anthony Mason, leaned over and said, "Oh, Mr. Caston, we're not really interested in individual claims. Would you like to look at your prayer for relief and think about perhaps a communal claim to the whole of the island, for the whole of the Miriam people?" So Ron Caston said, "Oh, that's interesting, Your Honour. Yes, well, thank you very much. We'll look at that. Yes. Okay, we'll have a special hearing tomorrow at 10 o'clock. And if you'd like to address us then, Mr. Caston, court adjourned." So after 9 years, and I've recently written about this in the Monash University Law Review, after 9 years, we adjourned to our unit in Canberra, drafted amendments to the prayer for relief by adding, in the alternative, a communal claim by the Miriam people to the whole of the Murray Islands. We had, I should say, at trial, we lost everything offshore from the high water mark and realised that the case was issued against Queensland and the Commonwealth. The Commonwealth declined. Gareth Evans was then Attorney General to join us as a plaintiff. And the Commonwealth attacked our witnesses through their counsel. So we did a deal with the Commonwealth. Well, we didn't have a lot of evidence about the seas. We withdrew the claim to the seas. The Commonwealth then left the case. And we, however, maintained Commonwealth jurisdiction, enabling us to stay with the High Court, not be sent off to the Queensland Supreme Court. So we turned up in court on the last final morning, scheduled for 1 hour, handed up our amended prayer for relief, seeking in the alternative that there be a declaration in favour of the Miriam people. We didn't know who they were. We had no instructions. Most of them lived on the mainland and we'd never met them. And there was absolutely no way we could have sought such instructions. The Miriam people enjoyed traditional rights and interests to the Murray Islands. And that was the final declaration of the High Court, only concerning Murray Island to the high water mark, not the two adjacent islands which were part of the original claim. So it was a claim full of surprises.
It was indeed. And so I think that just to conclude that, let's get to the point of the judgment. And I understand that Eddie Mabo died before the judgment was delivered. So although his claims had been unsuccessful, he didn't get to hear the final outcome. And then you could just tell us about how the outcome was delivered and how you actually advised your clients.
Well, I should add, again, if I may, Eddie Mabo was critical to the case because he drove it. He understood, he was extremely intelligent. His English was better than mine, and he spoke Miriam Mer. He found the witnesses because he understood what a witness had to do because we told him about it. He explained custom and tradition to us, and he explained this weird Anglo-Australian legal system where this guy in a black robe would stand up and ask you questions, and then there was a judge, and then there was another guy who'd cross-examine you. So, although he failed, he was critical to the case. How did I advise the clients? Well, I took judgment in the High Court, and guess what? We had won, 6-1. I repaired upstairs to Council's chambers in the High Court building and rang the only phone number I had for Murray Island, and that was to the public phone booth outside the Council chamber. No internet, I'm talking 1992. No iPhones or anything like that. So I rang that number, and a lady answered, and I said, "Hello, I'm Brian. Do you remember the Mabo case?" And she said, "Yes." "Well, I'm in the High Court, and the judges have just handed down the decision, and you've won your case." And she went, scream, "Oh, wonderful, thank you very much, and dropped the phone. Well, I was left swinging in the breeze, listening to her careering down the main street, yelling and screaming, and telling and spreading the good news. I understand there was a big party at Murray Island that night, and I was not invited, and I did not attend. If you want to read all about it, that's the opening paragraph of this book, which is my PhD thesis and also my book describing the torturous 10 years.
So thank you. That's a lovely start to where we're going. And so I want to fast forward 25 years and come to you, Shireen. In 2017, oops, which way to turn it on? In 2017, the Uluru Statement from the Heart was published as a call from Aboriginal and Torres Strait Islander peoples to work for a First Nations voice. The statement is the output of decades, or indeed more than a century, of Aboriginal and Torres Strait Islander activism for appropriate recognition for Australia's First Nations people. The statement calls for three things: recognition of sovereignty, which coexists with the sovereignty of the Crown, and that's never been ceded; recognition of a First Nations voice in the Constitution, and a Makarrata Commission to oversight agreement making between governments and First Nations people, and truth-telling about First Nations history. Somewhere around, we actually have printed out some copies of the statement so that you can have a look at them. Successive Commonwealth governments since 2017 have not heeded the statement, although a referendum is now on the agenda. Shireen, your work on the Constitution and the Statement from the Heart is about the importance of the voice. Can you talk to us, please, about why the voice needs constitutional recognition?
Yeah, thanks Jenny, and thank you, Brian. What an amazing insight into this decade-long, torturous, as you say, battle. And it just makes me think, like, such a battle for 10 years to give only, I think it was a historic and monumental decision, but an initial sort of snippet of justice. And I think what we're acknowledging and discussing here today is how much further there is still to go. And to think that before 1992, the legal position was that this land belonged to no one before the British arrived. Till 1992. Like, that is slow going for just the first step towards fulsome justice for First Nations. And I say just the first step because it was a massive win for the Meriam people and a massive step forward legally and politically to overturn that fallacy of terra nullius. But in terms of the substantive justice that was delivered, the decision, I think, had its limitations. Firstly, because the title that was recognised was susceptible to extinguishment by the Crown. So, and you know, the requirement that claimants needed to show largely continuing connection to their land under traditional laws and customs, as shown through proof presented in a High Court, you can see how that would exclude perhaps many of the First Nations who've suffered most brutally at the hands of colonisation, right? As we saw in the Yorta Yorta case, which I think 2002, wasn't it? So the other limitation of this court-delivered snippet of justice is that it's not available to every group that suffered at the hands of the colonisers. And then the form of title conferred, the communal, inalienable form of title conferred, also has limitations in that it's not always economically of great use to the empowerment of those First Nations. It can be hard to pursue fulsome economic, cultural and spiritual development on native title land sometimes, different for different groups, but it can be hard to pursue home ownership on native title land and adjoining systems, which led to the former Indigenous Affairs Minister Amanda Vanstone. She observed once that, in many Indigenous Australians across the country are land rich, but still dirt poor. So, yes, it was an important step towards justice, but Australia's still failing comprehensively to close the gap. We still fail to fulsomely and properly acknowledge and celebrate the Indigenous history and heritage of this land. And to speak to your question, Jenny, why does the Uluru Statement ask for a First Nations voice, so essentially an Indigenous advisory body that would be empowered to provide advice, Indigenous input on laws and policies made about Indigenous affairs? Why does that need to be in the Constitution? Well, because legislative justice can be undone. So look what happened with the Native Title Act that was enacted after the Mabo decision. A few years later, when the Liberal government got in under John Howard, he enacted the WIC 10-point plan, which really watered down the Native Title Act. Look how the Racial Discrimination Act, which was so fundamental, as Brian explained, to the achievement of the Mabo decision. If we didn't have the Racial Discrimination Act, as Brian said, that initial claim wouldn't have succeeded. And yet look how easily the Racial Discrimination Act can be swept aside. It's been suspended, I think, around 4 times since its enactment, each time only in relation to Indigenous people. Indigenous people have had representative bodies in the past as well. ATSIC was set up under legislation again. When governments changed, the legislation was abolished, actually with bipartisan support, to be fair, and ATSIC was thrown down the gurgler. So, as Jenny said, Indigenous people for decades and since the 1920s, probably long before, have been calling for structural and constitutional reform to enable their self-determination, their empowerment, to enable their voices to be heard when governments make laws and policies about them. The logic being, I guess, that when Parliament and those politicians in Canberra are considering, should we water down the Native Title Act? Should we get rid of ATSIC? Should we suspend the Racial Discrimination Act to enable the Northern Territory intervention? That the Constitution should require those politicians, at the very least, to hear Indigenous opinions, the opinions of the Indigenous communities affected, before they enact those laws and policies. And what the Uluru Statement argues, that if those decisions could be made in partnership with Indigenous people rather than unilaterally in a top-down way, then hopefully they'll make better laws and policies, because they'll be co-designed in partnership with the Indigenous communities who know their problems best. And then hopefully maybe Australia will start to achieve better outcomes over time in terms of closing the gap. So why does it need to be in the Constitution? It needs to be in the Constitution so that future governments can't get rid of it, right, like they did with ATSIC. It needs to be enacted in legislation so that the institution can evolve over time, because that's needed. It will need to improve over time. When problems arise, Parliament might need to adjust the legislation. But there needs to be that fundamental constitutional guarantee that Indigenous people will always be heard when politicians and policymakers make decisions about them. So under this government, we are going to have a referendum on this. The government's committed. So we now all have this incredible opportunity, but also responsibility, because as Jenny said, constitutional referendums are really hard. They usually need bipartisan support. So we need every single Australian of goodwill to be out there helping explain this, helping refute the myths, answer questions, and help secure a yes vote in the upcoming referendum.
So, Shireen, thank you. There's a few constitutional law students in the audience who have their exam tomorrow. So I have promised that we would touch on one more element about the Constitution, because a number of the people in the room, last constitutional referendum was in 1996. Could you explain to them what we have to do to actually pass a referendum?
So the government needs to finalise the words of the amendment. So I think that there are several committees operating now, but what it will need to do is decide precisely what the words of the amendment are going to be. Then they'll need to initiate a bill which needs to go through Parliament. And once that bill is passed, then we will vote in a referendum. And the referendum will require a double majority. So that means a majority of voters in a majority of states need to vote yes. So it's much more onerous than just a simple 50% like in an election. It's, in the 1967 referendum, Australia's most successful referendum was 90% of Australians voted yes. Does that answer your question, Jenny?
Yeah, it does. Thank you very much. And of course, the 1967 referendum is the referendum which recognised Aboriginals as Australian people. So thank you for those comments. And that's a nice lead-in, Mark, to talk to you. Wanted to talk about the First Nations voice and the Makarrata coming together after is about coming together after a struggle. And it aims to capture aspirations for a fair and truthful relationship with the people of Australia and a better future for the children. It's a huge aspiration given that we've had an abysmal performance to date. Can you talk to us a little bit about your experiences and how you would see the Makarrata delivering change? And I'm going to follow up with will it support an aspirational class of Aboriginal people?
Thanks, Jenny. I just want to join with Di in acknowledging that I'm on her country. This is occupied Melbourne, or Naarm, as we refer to it as, and pay respect to herself and her elders and her community. And I live, work and play on this country. And in doing so, I want to bring the compliments of my elders, the Gunditjmara of Western Victoria, and the respect of my ancestors to this gathering. I use that term on occupied land. I'm actually doing a Harvard subject at the moment on public narrative, and our colleagues on Turtle Island, which is the Americas, do that in their acknowledgement. We talk about unceded land. They come out and hit between the eyes and say, it is occupied. And I had that conversation with the Greens person handing me out a how to vote card, and this morning on the way to the tram, which was an interesting exchange, but I digress. Look, I'm not a lawyer. I've used lawyers a couple of times, and I want to congratulate you on that 10 years of torturous work and also very rewarding work, and sharing to you and your work. But the torture has been around for a lot more than a decade. And, Jenny spoke about I was 12 years of age before I became a citizen of this country. And I recall my father, and who a stolen kid, removed from Framingham Mission, the first cousin of Roy Rose, Lionel Rose's father, and he was used as a slave, despite what former Prime Minister Morrison said. and at the World Indigenous Conference two weeks ago in Adelaide, it was our First Nations colleagues from Canada wore orange shirts to remember the skeletons have been dug up at orphanages, and on the stage I paid respect to that, but I said those ones who weren't skeletons, who left the orphanages, never really made it home, and their screams at night still haunt. So I would say the treaty here in Victoria, the statement from the heart, are big ticket items, and they are of value and they are symbolic. I'm a bit jaded, I have to, this is not group therapy, I don't think yet, but I am jaded. I was around at ATSIC. I remember the joy of us having a carrot wag in front of our noses that we're going to self-determine. And that was really exciting, but a very unreferenced PhD, which is mine, will say that at the time of ASIC, there were 5 Aborigines with MBAs in the whole country and 1 Aborigine. In fact, the sister of Auntie Di, who was a CPA. So how the hell were we going to self-determine? It was an aspiration that goes back to the 30s. Jack Patton, Ferguson, William Cooper drove that change. And they created NAIDOC awareness in the same year that there was a massacre in Alice Springs. So they created this wonderful event with fear of their lives in hand. So what I'm going to say there is I was in Adelaide at the start of the Aboriginal Congress, part of that, really rich, that came and went. ASIC came and went. And while I am buoyed about the feeling and the spirit and the expression of statement from the heart, I carry around a bit of reservation in my being, because why people talk about big ticket items like this, and I support the people. I love Megan. I've known her since she was a kid. Geraldine, I see her as a sister, and her family and I are really close with treaty here in Victoria. My personal treaty is getting as many black kids through uni so that sovereignty won't be given, it'll be seized. If we wait for the government to give us sovereignty, that's a colonial act. We have to create a mass of talented, skilled Aboriginal people of aspiration, and we have to seize sovereignty. So why I fully support the aspiration of it, I haven't drunk the full cup of Kool-Aid yet. So I might be being a bit negative, but I have seen the downstream effect. If you want something to sober you up in the middle of the night, go through the experiences I have had when I co-chaired the Royal Commission implementation into Aboriginal deaths in custody. There is nothing more sobering than hugging a kid as if you thought that if you let go, you would fall into an abyss. A kid who tried to hang himself with his midnight oil T-shirt the night before because he found the surrealism of the criminal justice system better than the realism of his own life. So what I would like to feel and see is a nexus, a conduit between this big aspiration. It's important, it's got to carry on, but it's not distracting me from my personal treaty, my personal ancestral mandate to get enough kids through university in my watch so that they can create a future. This work is really important, and I do congratulate, and I hope I'm not sounding disrespectful. I love Eddie and Gail and particularly Gladys, who danced, 5 teeth in her head but spoke 5 languages. And the notion of us, not being intelligent. Eddie was dirt smart. And he worked in while he was working in, the Mabo, he was also working in education. So it's great. So how do we make, sure, and we do it for my personal treaty by working with faculties, and law and business are the two that I see as really important, because I believe Aboriginal and Torres Strait Islander people will be returned to a sovereign position in this country. The young people have a go at me and say, "Unc, why don't you come down and protest?" And I say, "No, you're asking for the government to give you sovereignty. And if you bestow sovereignty, it's still a colonial act. Become deadly," and that's our word of being great. Become deadly and go and seize sovereignty. Don't wait till it to be handed to you. But while the war continues, and I am so buoyed about the work that it's been done, but it's not going to distract me from the work I do. Don Dale, Kumanji Walker, the 9 coroner's reports that I read word for word. The young woman in St Kilda who brought a tomahawk at Bunnings or McEwen's when it was then, and went to a counselling session, and a young social worker who thought that was worthy of breaching, and the 5 bullets that were put into her in an alley. And she's one of 9 that were killed in custody during the time. Now, I can get in the argument whether they were, accidents, but for those 9 people, the black system and the white system fell down. So we've got to make sure that we've got the law system that's tuned to understand our need. In fact, every graduate of this place needs to go out and see things. Coach, I don't want them to join me on a NAIDOC Day march, and I don't want them to barrack for the Rabbitohs in Sydney. Who do you barrack for in Sydney? No, South is where all the blackfellas go. But I don't want them to become pseudo-Aborigines. I just want them to be good at their craft and be able to see their craft from a duality of perspectives. So if that can be incorporated in a high-level Makarrata, great. But in the meantime, I'm going to get on with my work.
So, Mark, that's actually fascinating, because you've talked about what's almost a parallel universe. While we try to do the statement from the heart in one side, that we actually continue to try and fight for rights on the other side. And so, Brian, I know that one of the things that you've been looking at since Mabo is the legislative reforms, the treaties, the other cases that have actually built on rights of Aboriginal communities, sometimes taken them away. So I thought you might like to talk to us just for a few minutes about what's been going on since 1992, 30 years ago, and before we got to the statement from Uluru.
Well, a lot's been going on, and a lot of it follows belatedly events in other English colonies. Australia is way, way behind equivalent countries. Let me just give you some very quick dates. The equivalent Mabo case happened in the United States in 1823. Chief Justice John Marshall, in a case called Johnson and McIntosh, in 1831, the Supreme Court of the USA, again, described Indian tribes as, quote, domestic dependent nations. 1831, okay? In addition, remember, in the United States, under the Constitution of 1788, the Article 1, Section 8.3, I am a lawyer, says that the Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So from day one, contrary to our Commonwealth Constitution of 2000, when was it? 1901, the US Constitution recognised alongside several states and foreign nations, the Indian tribes. So again, Australia way behind. Let me take you then very briefly to Canada. The Mabo case in Canada was decided in 1973, a case called Calder in British Columbia. And indeed, that case established the basic principle. Again, in 1984, a case called Guerin was decided in the Canadian Supreme Court. That established for the first time that Canadian governments, when dealing with Indian title, owed the traditional owners a fiduciary duty. Now that's important. We argued fiduciary duty in Mabo. The only judge who really got hold of that notion and discussed it extensively was Justice John Toohey. He was Justice Dean and Mary Gaudron agreed with him in principle, but the other judges declined or rejected it. So we did not get up on fiduciary duty. You constitutional law students sitting here, you are now charged with the responsibility of raising this question in the High Court and establishing in Australia that governments owe Indigenous communities a fiduciary duty when dealing with their Indigenous rights. Okay? Easy. That was that was Canada. New Zealand, 1845. I beg your pardon. 1840, of course, we had the Waitangi Tribunal. The equivalent Mabo decision was handed down in 1847. Right? We are way, way behind. Let me just take you to another point of development in Canada, and that is the relationship between treaty making and the 1972 Calder decision. In Canada, you have historic treaties in Canada. Between 1701 and 1923, there were about 70 treaties. 70. And they were 364 First Nations, representing about 600,000 First Nation people in Canada. Then there was a long gap. Then there was a Calder case in 1975, which triggered further treaty negotiations and priorities and initiatives. And between 1975 till today, there have been 25 further treaties. These are comprehensive land claim agreements. Some include powers of self-government. And those are with 97 Indigenous communities, representing 89,000 Indigenous people in Canada. Couple that with the constitution reforms of 1982 in Canada. Constitution students, listen to this. Part 11 talks about the rights of Aboriginal peoples of Canada. Section 35(1). The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognised and affirmed. 1982. And Section 35(2). Aboriginal peoples includes the Indian, Inuit and Métis peoples of Canada. So the Australian political and electorate and the Australian electorate has to realise just how much we have to catch up still. Let me say, in drafting the Mabo pleadings, we did not deliberately touch the question of sovereignty. We left it to one side. Firstly, we knew that the High Court would not entertain the issue. They considered it as an act of state, as a political item, and the High Court will not entertain that question. Code discovered that to his anger when he raised the sovereignty question, we therefore in the Mabo decision looked at the question of, does the common law of Australia as inherited recognise traditional rights in land, as has been established in Canada, the US and New Zealand, equivalent common law countries. So we left sovereignty aside. But the High Court, since that decision of 1992, has re-entered this arena to an extent in the Love decision of 1919. You remember the Love decision talks about whether or not Aboriginal people, Indigenous people, Aboriginal and Torres Strait Islander people can be aliens quote unquote, under the Constitution, Section 5119, and decided they could not. Why? Because they decided, and particularly look at majority judgments, that the Indigenous peoples of this country had a special spiritual, cultural, economic relationship with the land, and that relationship had nothing to do with legislative rights provided to them by the parliaments or the governments of Australia. It was inherent to them. And it looked at Mabo and the fact that Mabo did not enter into this arena or dodged the issue. And have a look at the important judgment, of course, of Justice Gerard Brennan, sadly now passed away. They did not enter into the question of, do the Indigenous people enjoy traditional rights as sovereigns? They declined to address that, dodged the issue, and dealt only with the questions of land rights. So after the Love decision, the High Court has opened up a new arena of debate touching upon special relationships to country, and that's getting very close to sovereignty. Let me take it one step further. The experience of the Native Title Act has been positive and negative. On the positive side, we have about 50% of this country now the subject of native title determinations or claims. In Western Australia, it's an astonishing 80%. South Australia, similarly. Victoria, if we include the Tangerong settlement, something like 40%. So there are major areas of country, the subject of native title determinations involving, when you think about treaty discussions, one, a recognised delineated traditional owner group by reference to apical ancestors, and two, a specifically designated area of land. And let's leave aside for the moment, and I completely agree with the proposition that the rights granted are very fragmented, very inadequate, subject to extinguishment, particularly following the Howard amendments of the 10-point plan. That's to be compared with rights generated under the same regimes in Canada, where you have a much more holistic underlying native title right, which is not described by 10 or 15 things you can do on the land. Hunt, fish, gather, forage, conduct ceremony, conduct teaching, and so on and so forth. That is a holistic single right to country in Canada, which we do not enjoy in Australia, which Indigenous people don't enjoy. So one of the positives in the native title regime at the moment, however, is a trend towards joint claims by several communities running together. The good example is the Noongar claim in Western Australia. 6 Aboriginal traditional owner groups got together and over a torturous decade finally negotiated an agreement involving all of the Noongar communities, achieving a settlement with Western Australia involving major millions of dollars of money, involving many tens of thousands of Noongar people, involving institutions of government, and involving rights to do a number of things on country. George Williams and others, and I too, in an article in the Pandora's Box, have described that Noongar settlement as a treaty, as a domestic treaty, I called it. George Williams called it a treaty, which answers the criteria of international treaty requirements. Now, there's an example of one way forward for treaty discussions in Australia, i.e., all of those determinations over 50% of the country can be a foundation, a stepping stone towards let's have an agreement which not only deals with rights and interests in land, activities on land, entitlements to payment if you extinguish our native title, etc., but adds to the issues on the table rights of self-government. Some of those rights are already there to be seen in the Noongar settlement, and that seems to me to be one avenue of treaty discussions that is already underway. A second avenue is various cultural groups in the community. For example, in Victoria, groups that are associated with the Aboriginal Heritage Act, and are recognised groups who have to be dealt with on the basis of their statutory rights concerning Aboriginal heritage.
So Brian, I'm going to stop you there,
Yep.
mainly because it's a really interesting juxtaposition of where we can go with legislative reform. Whilst you're talking about Canada, I have in my head Mark's comment about that although Canadians recognise title, with all those children who were found buried and the orange shirts. So just to add, I have a bunch of other questions here written down, but I'd like to hand over to the audience for questions that you might have to ask any one of our panellists, if I may. And we'll start with Mike Ewing, who's our Executive Dean of the Faculty of Business and Law. Thanks, Mike.
Thank you.
Do you need a microphone?
Do I?
Yes.
I don't think so.
Partly for the recording as much as anything
Thank you.
else, Mike.
So I'm a lay person, I'm not a lawyer, so I've got a question for Shireen about the practicalities, because now you've got me worried with what you've said. So I need you to talk me through the process, and then I need your expert view on the probability of success. Because, remember, 4 out of 10 Australians were opposed to marriage equality. Everyone celebrated that referendum. I thought it was bitterly
But it
disappointing.
wasn't a referendum, of course. It
Well,
was
whatever it
it
was.
was a plebiscite, not it didn't
Okay.
have to be a referendum.
Fine, but
Yep.
the fact is, four out of 10 people still thought that wasn't a good idea. So that doesn't give me confidence, all right? So I'm already a bit nervous. I'm with Mark. I'm starting to go a bit more pessimistic here. And I agree with Mark that constitutional recognition and treaty is not a silver bullet. And I agree with Brian. It's not progressive either. It's simply, in the game of catch-up footy, we go from 40 years behind New Zealand and Canada to 20 years behind. So on some levels that's progress, on other levels it's not. But I need you, Shireen, to calm me down, because I'm starting to get worried now that this is not going to come off. If 5 out of 10, and I don't want to be racist, but if 5 out of 10 Territorians and Queenslanders have to vote yes, I'm starting to get nervous. Can you talk me through the process? And like I said, in your view, is it a done deal, or do we need to be worried?
Well, I think we need to do the hard work, is the way to think about it. I think it would be stupid to sit back and be lazily optimistic and think, oh, we've got this in the bag. No, constitutional referendums are very difficult to win. Very high levels of political consensus are needed because, as I said, you need a majority of voters in a majority of states. So you need 4 out of 6 states to have over 50% vote in each of those states. And
every state, just 4 out of 6.
a majority of the states, so 4 out of 6, right? And you need a majority.
And not Northern
Sorry?
Territory or
Again,
Canberra.
territories, territories were involved only to the extent that they are part of the electorate and therefore are voting to achieve a majority of the electorate. The second hurdle is a majority of the 6 states, 4 out of 6.
So it's difficult. I think we're in a really good position because most of the polling that's been conducted shows a strong majority of support. I also think that advocates in this cause have been really strategic and smart. This is a proposal that, in my work with Noel Pearson and Cape York Institute, has been pushed by Indigenous leaders since 2014, actually in collaboration with constitutional conservatives, right? So there are key people across the political spectrum who support this proposal, which is unusual. Right? So we don't don't yet have formal bipartisan support. Nonetheless, a lot of groundwork has been done to secure important support on the right as well as the political left. So people have been doing really hard work to give this the best chance of success, but the hard work can't stop now. The hard work has to now really, really ramp up. So I would encourage you and everyone here, everyone who wants to see a good outcome in this referendum, to really start putting your heads together and talking to people who know and thinking about how can you help, you know? How are we all going to work together to ensure this succeeds? And this can't just be the job of the Indigenous 3% on their own. Because this requires such high levels of political consensus, every single one of us, Indigenous people, non-Indigenous people included, need to really feel a sense of responsibility here. We need to know that it will be hard to win, but you know, I think there is heaps of goodwill. I think Australians really do want to close the gap. We really do want to see better outcomes and really do want to resolve some of these really terrible elements in our history. So I think we've got to work together to make sure this succeeds. And I think, you know, this is a modest and sensible and practical proposal. They are really not asking for much here. They are asking for a constitutionally guaranteed mechanism to simply give advice, non-binding advice, when Parliament makes laws and policies about Indigenous affairs. You know, if we all went out and committed to doing our bit, to talking to Australians who've never heard of this, but explaining it and answering questions and allaying fears, I think we can win this if we do the hard work.
Thanks, Shireen.
Yes, and remember, the 1967 referendum had no case. There was no case funded by government or run by anybody. Okay, so that is a big distinction to remember. Also, the approach I take to this is exactly as Shireen has said. This is conservative, normal processes of advice to government. There are numerous entities, legislative entities around the country, which are taxpayer-funded entities with the purpose of giving advice to government on various areas. Australian Law Reform Commission, for example, where I worked for 3 years under Justice Michael Kirby. The heaps of other political or economic or human rights advisory bodies. That's all this voice is, an advisory body. Prime Minister Turnbull's suggestion that this is a third chamber was outrageous and was deliberately misleading. He's a lawyer, he knows better, right? Let me just...
Taken that back, Brian.
Yeah, good, he should.
He said that's not true and he said he'll vote yes now. So
and the simplicity of it should not be forgotten. And a lot of the arguments in the Australian by those normal anti-creative voices are making complications like the High Court will step in, which really aren't relevant. Remember what Albanese said at the Dagama Festival. This is last July. I'll read you the 3 sentences. 1, there shall be a body to be called the Aboriginal and Torres Strait Islander Voice. Okay? 2, the Aboriginal and Torres Strait Islander Voice may make representations to Parliament and the Executive Government on matters relating to Aboriginal and Torres Strait Islander peoples. It may, doesn't have to. 3, the Parliament shall, subject to this Constitution, have power to make laws with respect to the composition, the functions, the powers and the procedures of the voice. And in the normal democratic way, each ensuing government, no doubt, will amend that legislation should it so choose. There's nothing novel about any of this. Now, those are the 3 sentences that Albanese uttered in the Gama Festival in July, and it would be useful to see some further detail about the principles of the legislation.
Mark.
And just to agree with my colleagues up here, we need to grab the narrative around it. And this is about national maturity. It's about time that we as a people, as a whole people, had the conversation at your dinner parties, in your coffee shops, wherever you can. It's about national maturity, and let's grab the narrative rather than have it grabbed by Sky TV and everyone else around it. It's it's about us standing up and being the country that we are and should be.
And the other thing to note, of course, when people say, "Oh, there's no detail," hello. I mean, really, how many pages? 260 pages. It's a very readable report. It's very good. It's the final report of the Indigenous co-design process, which details what the voice might look like. It looks at national, regional and local voices, how they coordinate, how they should not override already existing Indigenous bodies, such as peak bodies, such as land councils, and a host of other bodies, and contains very reasonable propositions as to what this voice should look like and how it should function. And also adds the co-design process was deliberately constrained from discussing whether the voice should be entrenched into the Constitution. But there's a paragraph that says, and we received many submissions supporting the entrenchment of this voice in the Constitution after significant consultation around the country. And just remember, this process has been underway, to my knowledge, since the early 1980s with the Nugget Coombs Makarrata Commission, or Makarrata Committee, which was operating around Australia. Nugget Coombs was involved, Judith Wright McKinley, the wonderful Australian poet. Eddie Mabo was co-chair of the Townsville branch of the Makarrata Committee back in the early 1980s. We've been at this some years.
I might add that Eddie Mabo did a lot of his study at the James Cook University. He was employed as a gardener, but had very good access to the library, so made very good use of that. Thank you, thanks Brian for those comments. Any more questions? We've got Sam and then somebody else over here. Sam, first Samantha.
I better get a microphone, my voice. First of all, thanks very much, all of you. I want to go a bit higher. What about the Republic movement? I mean, a lot of what you're talking about is systemic. Mabo, of course, basically Brennan talked about being confined by an inherited common law. And I'm going back to land rights here. What about if we didn't have an inherited common law land framework and we weren't bound by a feudal system, which effectively it doesn't recognise a pluralist system. It's not going to have any capacity because all land rights are derived from the Crown. And of course, not all land rights are derived from the Crown. So what about the idea as we move forward, particularly with the imperatives of climate change, which are intricately connected to land rights, what about if we start thinking about how that might look? And that's sort of taking it a bit beyond, and obviously I'm looking at land rights, but it's really grounding us in the idea that it might be possible to move beyond the system that we've had for such a long time. And Brian, you referenced the United States and Johnson and McIntosh, but of course Thomas Jefferson abolished feudalism much earlier, and so they weren't constrained by that. They have an allodial framework over there. So I'm just wondering what the future might look like now that the Queen has passed and we may have a future where we're starting to develop a new land framework. What are your thoughts on those ideas?
Firstly, it's an additional layer of complexity. It attracts the political arguments about republic, and that referendum failed. And it runs the risk of drowning the particular Indigenous initiative in another initiative, right? My hunch is, though, that it gets to the heart of the matter, and that is the question of, did the British actually, at law, achieve sovereign ownership of this country? And the answer is clearly no. Governor Arthur Phillip or James Cook, forget which one, was instructed to establish a settlement with the consent of the natives, quote unquote. Stronger language in South Australia. Remember that Australia was colonised at a number of dates: 1788, 1825, Western Australia, 1835, South Australia and the Northern Territory. Remember also that the Torres Straits was colonised only in 1879, 100 years after the initial colonisation of the eastern seaboard. That was one reason why we thought this was a good test case, because we thought, 100 years less acculturation, less destruction, less dispersal. Maybe this is a good test case because the Torres Straits have been relatively subject to the Queensland government's very racist administration for 100 years, nevertheless relatively left intact, especially the remote islands, right? So when you look at those numerous acquisitions of sovereignty, the latest one being 1879, a real question is raised, are any of these valid? And if they're not valid, that is a question, of course, of politics, not law ultimately. It's a question of international law and political will to do something about it. Perhaps with the death of that lady in England, which requires me to change all my letterheads and at great expense, I'm going to send my invoice to the palace, I think. It is a moment to rethink those fundamental constitutional frameworks.
Mark.
And Sam, certainly the sidebar conversations at the World Indigenous Conference on Education, the Māori were saying, what happens to our treaty if we become a republic? Because our treaty is with the Crown. So I'm not a constitutional lawyer, but
That would be an issue.
another interesting complexion.
Shireen?
Well, firstly, lots of monarchists are passionate supporters of a voice in the Constitution. So I would not be in favour of combining those two issues. As Brian said, the Republic referendum in 1999 failed. So, this is the thing you always come back to. The only way to change the political system is ultimately via the political system. So we always come up against the need to build consensus for whatever the reforms are that we're pursuing. And again, on this question of sovereignty, agree with Brian, it's a political question. We might argue all day long about the legal invalidity of claims to sovereignty, etc., but at the end of the day, that's an academic point. Because how is sovereignty asserted around the world? Well, it's asserted usually through horrific violence and guns and tanks and ploughs, And that's what we saw in Australia, was that violence, that political, military assertion of sovereignty that won out. And now it's up to our politics to sort that out in a more just and fair and humane way. So, I agree that, in an ideal world, we would want to go back to basics and rewrite the whole thing. But in reality, that requires political negotiation to rejig the entire system, which is a really, really big job. So I think we should start with the voice referendum. Let's do the work to get that to succeed. And then perhaps the referendum, the Republic question, is one that can be answered down the track.
There is precedent, and a good example is the Swami people of northern Scandinavian countries. You talk about that, you know about the Swami.
Yeah.
They have their own parliament, have had for 20 years, their own sovereign micro-states, international entities within Norway, Sweden, Denmark, am I right?
Finland, yeah.
Finland.
Yeah, and they were represented at the conference last week, and it's a model that works over there, and it's...
And here are communities of what, 5,000, 10,000?
I'm not too...
Micro-states recognised internationally as independent sovereign states. Now, how do they economically survive? Good question.
Well, just on that, we've got time for one last question from the audience. If anybody would like to ask a question, yes, down the front here, and then we're standing between you and a drink and something to eat, and so I'll finish up.
I'll be quick.
Thank
you. I'll be quick, Shireen. Some of the public discourse currently is around the concept that a voice is subservient to Parliament, therefore is weaker than a treaty would be. Can you put some comment to that at all?
So I think, the thing that the Uluru Statement did, which was a real breakthrough in this debate, was it broke through this perceived false dichotomy between, Indigenous people have to choose, do they want proper recognition in the Constitution or do they want a treaty? Because if you remember, it used to be you're either in the recognition camp or you're in the really cool treaty camp, And I think there was a bit of myth around the idea that a treaty would deliver something much stronger. And I say that's a myth because you look around the world and lots of countries have had treaties between Indigenous peoples and colonising powers. It's not a silver bullet. The Crown, the colonising entity, always is the more powerful party, and they often breach their own treaty promises. So again, it comes back to these power dynamics. But the thing the Uluru Statement did was say, no, it's not either or. We want both. It said we want a voice guaranteed in the Constitution and we want a Makarrata Commission to facilitate agreement making or treaty making. And to me that makes perfect sense, right? Because you look at what's happening in Victoria now, undertaking a treaty process, but what was the first step that Indigenous people had to do before you could even start treaty talks? Well, create an entity, create an institution that can liaise, negotiate with the government and eventually negotiate treaties with the government. So you can see an Indigenous body and the idea of treaties go together really logically. So I think this idea that a treaty is more powerful is wrong because just think about it logically, right? Yes, an Indigenous body would have to be created by the Parliament and it's respectful of parliamentary supremacy in a legal sense. But a treaty doesn't exist unless government agrees to sign the treaty. So a treaty too is subject to the realities of politics. There's just no escaping politics, and none of these reform solutions is a perfect solution. They're all about compromise,
So I think we leave today's meeting with homework because we've all got homework to do in relation to the Statement from the Heart and what happens with the referendum. So take that on notice and we'll be checking up on you. And then thank you to our panellists who've done an amazing job tonight, to Shireen and to Mark and to Brian for helping us understand what those issues are and where we're at. And thank you to Deakin Law School for 30 years. I mean, it's pretty amazing achievement in a young university that we've been around for 30 years, and this is a lovely opportunity to celebrate it. So thank you everybody for coming, and thanks to our panel, please.